So recommendation number 4 from the department is to allow private right of action for nonprofits as outlined in the Kim ordinance. This would allow a nonprofit who has in its charter that it is seeks to protect housing in San Francisco to initiate private right action against units that have had an Ellis Act eviction, or ones where there are 3 or more rent-controlled units prior to the department finding that there is a violation. So there's a process. One is 45 days, one is 30 days, but basically after a period of, say, 90 days, they can start initiating private right of action if the department has not found there is a violation yet.
Commissioner Antonini.
Well, I'm not supportive of this because I think it just encourages litigation, and the city should be the litigator. They should be the one that is enforcing these things, because why do we give nonprofits like a special privilege and above and beyond anybody else? I mean, I think that we should kind of stick with firm controls that the city has, and we should be the enforcer. It should be consistent, because sometimes some groups get ulterior motives, or sometimes it gets blurred because you're not really sure. So you've got all these lawsuits going on, which would make the whole process more expensive for all concerned. So I'm against it.
Commissioner Johnson.
Thank you very much. This actually, I have a question that goes towards recommendation 4 and 13 about private right of action. And so my question is, what would an outside party, not the city, be able to bring to the court, essentially? If they bring a private right of action and they're going before a judge, what information would they be able to have to prove their case, essentially? I guess I'm struggling with how private right of action supports our enforcement, because they're not going to have, definitely not more information than the city is going to have, and I struggle with how that would be effective. So look at Marlena, city attorney, or Aaron Starr, or Anne Marie, anybody.
I'm going to have to defer to the city attorney or Scott. I don't know what one would bring to the courts in a situation like this. Sorry.
Deputy City Attorney Marlena Byrne, it's really going to be up to that individual court to determine if there's enough evidence in the record before them to find a violation of Chapter 41A. Certainly if you file a lawsuit, then that opens you up to be able to seek discovery against the opposing side. So you can request their records. You can have, the court can issue subpoenas to third parties such as Airbnb or VRBO or those type of things to get records about the property. So, those are obviously all things the city can also seek when we are involved in civil litigation. So in that sense, I don't know that there would be any information that would be different than what we could seek, but it would just depend on what that person chose to go after.
Well, I would add that it's additional enforcement capacity. I mean, have the more people that are able to move enforcement cases forward. Additionally, some of the best information that we get is from those that are very close to the enforcement cases. There was a gentleman here earlier who had gave great information and that allowed us to pursue enforcement on the illegal unit that was in his building. So I think that they can add in terms of the information that's provided.
I'll just say generally this would be recommendation 4 and 13. I'm struggling with this because we're a little bit early in the game. If there were more case law on this, if there were more of an evidence base that people could draw from, like how do you prove that someone is violating the law, I would be okay with sort of throwing private right of action to anyone, really, and if they can bring that to bear. But I just think that I'm not saying how I'm going to vote because I haven't decided yet, but I'm leaning towards the city needs to be the one to figure out first how you prove that someone is breaking the law, and then allow others to follow in their wake to bring subsequent private rights of action after that first sort of wave has come by. So I don't know how you state that. I support it, but I just, the timing, it seems off to me. That's just my comment.
Commissioner Hillis.
So on this, I'm generally supportive. Can we walk through how this would actually work? Because it kind of gets into the recommendation. So I'm in a 3-unit building, and I live there. It's a condo. I think the upstairs neighbors don't live there anymore. They moved to Portland, and they're leasing out their unit through Airbnb for more than 120 days or 60 days or whatever we come up with a year. So I call the city doesn't do anything. Well, how would this work, actually? I'd take them to court?
So for this recommendation first, it's only for the nonprofits. So you being a resident
No,
of the
but
building.
just generally on the private rights of action. I mean, we can kind of get into who can do it,
Yeah.
but so,
You would, you'd first have to file a complaint with the city.
yeah.
Depending on the ordinance, or depending on which private right of action, say you would wait 30 days after filing that complaint. And if
But the city doesn't necessarily have to opine yet on the complaint.
No, you wait 30 days, and after that 30-day period has passed, nothing's happened. So you send a notice to the city saying, I'm going to institute civil proceedings against this person because you haven't done anything. They send it to the city's attorney's office, they send it to our department, and then they wait another 30 days, and then they institute civil action in the courts.
And I'm asking the court to enforce the law, or am I
The law.
asking
You're-
for monetary damages?
Presumably, this goes to Commissioner Johnson's question, they would have evidence that said, we know these people are breaking the law, and we can prove it in court, and the city's taking too long.
And-
Go
ahead.
Just to answer that last part of your question about the remedies, what
Yeah.
you would be able to get, it's different under each of the ordinances. Unfortunately, it's a little complicated. So under Supervisor Kim and Breed's ordinance, for Supervisor, the amendment that was proposed and voted on by Supervisor Breed, which concerns the Ellis Act. Well, I'll go in order, actually. So the one that involves the Ellis Act, which is the first one listed in Supervisor Kim and Breed's ordinance, that one allows an interested party to get an injunction, to get damages, and but cannot get civil penalties, and that's the same with Supervisor Kim's. They can get an injunction, but not damages and not civil penalties. Under Supervisor Campos's, they can sue an interested party, and for his, it's, I believe, any interested party. It's not limited to nonprofits. And the interested parties are, I should have made a table for myself. The interested parties are a permanent resident of the building in which the tourist or transient use is occurring, any homeowners association associated with that, any permanent resident within 100 feet of the property, and the nonprofit organization. And they can sue either someone who's actually offering the building or a hosting platform who's violating their requirements under the ordinance. And they would be able to get injunction, damages, and civil penalties. And the civil penalties are all set at $1,000 a day. And under Supervisor Farrell's ordinance, only interested parties who are permanent residents of the building or who live within 100 feet of the property and homeowners associations may file a private right of action, and they are only entitled to injunction and damages, not civil penalties. So
what do we what's the planning staff recommending? Sorting all those out, what's the recommendation on?
We think the limited private right of action for nonprofits is okay.
But on the whole thing, like, what are damages and what are?
A lot of this information we didn't have time to evaluate because it was just introduced at the time. So we, in the Campos and in the mayoral ordinance, those details weren't given to us. So I don't have.
Okay. Did you make a recommendation on the 30 days?
On the time limit?
Yeah.
No.
Kind of.
Okay.
you mean for notice to the city attorney?
Or that, 30 days after the complaint, you can file a civil act.
Those are also all different in each of the different ordinances. So that is not a uniform 30 days.
Right. It's 45 days in one, 105 days
In
and then
Farrell's.
Farrell's and 30 days in one. So I think The amount of days doesn't, probably longer the better so that we can have time to
Right.
do it. But, I mean, they're splitting hairs over 15 days, so I'm
Yeah.
not sure if it was.
Okay, thanks.
Commissioner Richards.
I think we heard from Supervisor Kim that this is basically a 35-year-old precedent. It started with SRO conversions, and private rights of action are allowed to happen by any nonprofit, and it's been working. So I think to Commissioner Johnson's point, this is not something new. She listed 5 or 6 other examples. If you're a nonprofit, you're not going to just be created out of thin air to start suing somebody. It's really somebody who's a bona fide nonprofit that has in their mission statement something around affordable housing or whatever we're dealing with here, the specifics, and it's kind of common sense, good government to me.
Commissioner Wu.
I think building on what Commissioner Richards just said, there has been this long history with SRO units either being actual places where people live or used as a hotel. And there was a lot of illegal conversion to hotel, right? And so this is something that worked well in the Tenderloin in particular to stop those bad actors from shifting these supposed home rentals to hotel rentals. And so I think that there's some good precedent there.
Commissioner Moore.
I believe it is good policy for us to support the nonprofits as they always have been the stewards and the professional guardians of this vulnerable population. So I think it is something, particularly with the emphasis on better enforcement, which I feel strongly to support.
Commissioner Antonini.
Well, I disagree because I've seen in my years on the commission many instances where the mayor's office and the city administration is generally very much in favor of a project, and the very nonprofits that we're feeding money to are coming out and bringing people in to oppose what the city's position is. So, I mean, I think that there's probably a reason why we haven't taken an action on something, and to get somebody else into the act is not a good idea, because I think there are a lot of political motivations that get into there. So I'm not voting for this one.
Commissioner Hillis.
Okay, just to follow up, is SR, or the hotel conversion the only place this is allowed? I mean,
It is in Chapter 41, and it's actually a bit broader. It reads that an interested party may institute a civil proceeding for injunctive relief and damages, and it just states that they have to notify the city attorney's office. So it's pretty broad. I believe, and no civil penalties.
but somebody adds an illegal in-law unit, or you're using your PDR space for office. You know, those are policies too we have. I mean, it's a little odd to me we're singling this out from all the other policy issues we make to allow it. But so that's it. I mean, you could only do it in SRO hotel conversions, not in other.
That it's elsewhere, but I'm just most familiar with it being in Chapter 41 and having been in there for quite some time, having, from my understanding, being successful.
Okay.
I mean, it does at least relate to housing. I mean, so similar to that was Chapter 41. This is Chapter 41A, both relating to housing and preserving housing.
But even if you Ellis Act and then you start re-renting it before you're supposed to re-rent it, we don't have that. You know, it sounds like we don't have that provision. You got to go to the rent board or whomever and get that actually.
I don't know if someone can institute a civil proceedings independently of the city for violation of the Ellis Act. We'd have to research that, I think.
Okay.
Given that it's a state law, it may apply. But.
Commissioner Johnson.
Thank you very much. I will say that I still am, I know the precedents in the Tenderloin. I'm a little troubled by this because STRs are a little bit different of a circumstance than SROs. I'll be supportive, but I'm just going to say right now, because we're talking about adding things at the end, I'm going to suggest that we make a recommendation about the types of remedies that can be pursued. I would be okay with more extensive private rights of action if it can be damages but not civil penalties, and if we had a longer length of time that the city had to review a case before a private right of action could be pursued. And I think that's something where the department didn't make a specific recommendation, and I would want to add it for me to be supportive of private rights of action more generally.
May I jump in? I could answer a couple questions that have come up. So one is that under the Ellis Act and under our local administrative code section or chapter 37, a tenant who's displaced under the Ellis Act and then the unit is re-rented within 2 years, they can bring an action for damages against the landlord. We also have provisions that are allowed under state law that if you re-rent within 5 years after you've done Ellis Act evictions and you bring a property back on the rental market, you have to first offer it to the tenants that were displaced, and there are restrictions on how much rent you can acquire for that unit. So I did want to circle back and answer those questions.
Commissioner Antonini.
Is it any nonprofit or just specific nonprofits are allowed to do this?
It's a nonprofit organization that has the preservation or improvement of housing as its stated purpose in its articles of incorporation or bylaws and has existed as such for no less than 5 years from February 1st, 2015.
Yeah, because I think a lot of them that are around, it may be, and that's what it may say theoretically, but they oppose a lot of projects that actually improve neighborhoods. So I'm not voting for this because I think a lot of the problems we have their origins in some of this knee-jerk opposition that comes out of these groups.
So, Commissioners, on recommendation number 4 to allow private right of action for nonprofits as outlined in the Kim ordinance, Commissioner Antonini.
No.
Commissioner Hillis.
Aye.
Commissioner Johnson.
Aye.
Commissioner Moore.
Aye.
Commissioner Richards.
Aye.
Commissioner Wu.
Aye.
And Commissioner President Fong.
Aye.
So moved. That recommendation will move forward with a vote of 6 to 1.